I've been referred to you. Was recently the victim of an assault in Shelby County and in my neighborhood, and I've been told that it was a third-degree assault, and I think under the law it very clearly is a second-degree assault, and I've not gotten satisfactory answers from anybody, and I've been referred to you, so I thought I would give you a call. Well, you're probably familiar with what I'm talking about.
I am, and basically, Mr. Schuler, with the facts that we have and the facts that were presented to the magistrate, it's their decision on what the charge is going to be. It's not our decision. So if it had been an on-view arrest where one of my deputies had possibly witnessed it or something and he felt that it rose to a felony, then he would have made the arrest on site. But once it's after the fact and it's preliminary investigation is done and it's referred to the magistrate, it's their decision. So it's not ours. So if the magistrate turned you down for a felony, the only thing you could request is the district attorney present the case to grand jury. And they rarely take a misdemeanor case to grand jury, but that would be the only suggestion I could make to you.
Okay. Well, I'm kind of confused because I'm confused about a lot of things, but I talked with Bill Bostic in the DA's office, and he referred me to is it Jeff Cardwell, the investigator?
Yeah, he's
Mr. Bostic said that they prosecute crimes, but they don't investigate them, and it's up to people like Mr. Cardwell to determine whether.
No. It's up to us to find the facts. We have done that, and the facts have been recorded on a report.
Right.
The report has been presented to the magistrate. Magistrate declined the felony. Now the only step you have to make is ask the DA to present it to the grand jury, and if the grand jury agrees with you, then they'll bump it up to a felony. But right now, the only thing you have is a misdemeanor assault at this point.
Well, I think one of the things that happens, and this may happen in a lot of cases, Deputy Stockman took the report, and he did a good job taking the report and the information, and I called him, and he said it was his decision to make it third degree. So that, right off the bat, I mean, he puts down third degree, and everybody just takes it right up the line as third degree. I mean, that's why the magistrate kept it as third degree. And
well, I mean, the facts speak for themselves. The facts that he recorded is why he made it assault third degree. And the facts read and judged by the magistrate is the reason it's assault third degree. And quite frankly, I've read it and I agree with them. So, that's where you're at, Mr. Schuler. I can't help you here. We've done our investigation. It's been referred to the magistrate. They declined your felony. The only other way is get the misdemeanor in court and then request that it be presented to grand jury. That's the only other.
Well, what do you mean get the misdemeanor in court?
I mean, if you want to go ahead and charge and sign a warrant for a misdemeanor arrest of the subject, and then at that point, once he is in the system, then you can request that case be presented to grand jury for possible.
But I have to move forward with it on a misdemeanor to do that?
Actually, you can make that request
to the DA's
office that it be presented, period, to the grand jury, and then but like I said, they rarely do that with the misdemeanor set of facts. So, but in the event that they do decide, then that would be, then you would be able to come testify to grand jury.
Mm-hmm.
And then the deputy would testify on his preliminary investigation, and then at that point, they may even call the alleged defendant in. So,
and there's an eyewitness to the whole thing who saw it, and
then you have another witness there that can testify to grand jury. So it would be up to them to bump it from a misdemeanor to a felony.
Okay. Well, I appreciate you explaining the procedure to me. A couple things I might mention to you if you have just a moment. I don't want to take much of your time, but part of the problem with I don't want to sign a misdemeanor complaint when it's not third degree. It's not only a matter of what it is, which is second degree, but it's not third degree because I've read this and studied it extensively. Third degree, the only element of that involves the use of a dangerous instrument, which is what this was, a big for sale sign involves criminal negligence. It's item number 3, and he was not criminally negligent. So it cannot be third. It's not only that, as you know, the law is very specifically written. It's not, well, it might be second, it might be third. It's either second or third, and it's not third. Because of that, he did not act with criminal negligence. He intentionally hit me. It wasn't like he was swinging the sign around and accidentally hit me, or was trying to hit somebody else and hit me.
Well, let me just be quite candid with you, Mr. Schuler. There's a way that the law is written, and there's a way that the law is enforced, and much of it comes by practice due to rulings within the court system on specifics to what is serious physical injury and what is physical injury. Now, those have been determined over and over again at the appellate level, and as a result, district attorneys get these rulings and they reduce it back down to the magistrate level, where in the event there was not serious physical injury, then they do not determine it being a felony. So at that point, they go with it as misdemeanors, and that's.
So what you're telling me, there's a set of law that's written, and then there's a set of law
where the court has intervened and dictated an opinion that is considered case law. And now I don't have it at the tip of my fingers, but I'll give you, for instance, breaking a bone is considered serious physical injury.
Right.
All right, that's the way it's defined in the code. All right, assault third degrees go all day long for people getting punched in the face and breaking their nose. They don't consider it, it's been ruled on the court that it's a misdemeanor. Same with cheekbones and stuff like that. So there has been rulings, I know that one specifically, but there's other rulings to the written word in the code that have been handed down by the appellate system that and I don't know why they do it, but they have ruled on the code as written, and now it is practiced that way.
And, well, I actually have some of those cases, right? I do have them at my fingertips.
Okay.
And I can give you some examples of what, and again, we're talking under second degree, if they use a dangerous instrument, it only requires physical injury, not serious physical injury. And that's why this is a mistake. Deputy Stockman told me, I asked him, he said, why did you make this third degree? He said, because you didn't suffer serious physical injury. And I said, I don't have to. Under item number 2, under second degree, it says only causes physical.
There again, I'm telling you the written word isn't the holding case here. So, but you're talking to the wrong people. The law enforcement is not the people that handle the case law. You need to talk to the district attorneys and the supervisors of the magistrates. They're the ones that make the determination on it.
Who are the supervisors to the magistrates?
Well, the magistrates work for the circuit clerk, and they're trained through the administration office of the courts down in Montgomery. So, that's who they work for. But I've given you the way to proceed here is to request this to be put on a grand jury.
Okay.
If the DA denies it, then you're done. There's no other way you can go.
Well, I know they're going to deny it because they don't want to move forward with it, but I've already talked to Bill Bostic, and he sent me to you all. I mean, I don't understand why he did that.
I don't know why he did either, but the facts have been collected. So, if he wants to present them to a grand jury, fine. If he doesn't, fine. That's between you and him. But as far as the finder of the fact, we have found it is, in our opinion, it was a misdemeanor. It was presented to a magistrate. Their opinion was the same. Now it's going to the DA's office, and so you're going to have to get determination from them.
Mm-hmm. Well, just if I can mention just real quickly, I do have case law right here in front of me. What has been determined to be just physical injury, enough to be second degree. It includes things like a skinned nose, a busted lip, a black eye, and in fact, in a case, Berger versus State, I think it was, in Shelby County, an individual being kicked in the shins was considered enough to be physical injury. So those are some examples. Why a broken nose would be third degree, I have no idea. But this is
third degree for being stabbed with knives. I mean, because it determined where they were cut was not threatening. So, I mean, there's all kinds of different different renditions of the law as it's written. And it comes down to how basically you work it in the jurisdiction you live. Now, who works that? You can quote the law to me all day long, but, you know, we're a finder of the fact. We put our opinion down there. The magistrate judges it. If they don't change it, then it's up to the DAs to change it. So, there again, talking case law with me is not going to help you. You can talk it with Mr. Bostic, it may.
Yeah, well, I've already done that. So, but anyway, and again, I don't know that this is this guy, the fellow who assaulted me, has a fairly lengthy criminal record already, and which is one reason. You know, I guess it just as a citizen, just making a statement, I'm starting to think, am I going to have to, you know, wind up with a hole in my chest, bleeding, dead, basically, before anybody takes this seriously?
Well,
and I